Ladies and gentlemen, you are in for a treat today. Today we're going to learn all about the world of probate, why you need a will, what happens if you die without one, and more. And our guest of honor is none other than my husband. Yes, my husband is real, and he's here in studio with us today, Spencer Turner. Buckle up, y'all. Welcome back to #Lawyered. You have Austin, your favorite legal A-team, in studio, and my husband. See, I promised y'all he was real. He's here. Spencer,
Hi.
welcome.
Thank you. Glad to be here.
We've been talking about having you on for a long time, so
Only took you 29 episodes.
That's a good point. That's a good
I just
point.
realized you guys are basically wearing the same blazer. It's a blue plaid.
Well, great minds think alike.
Yeah.
Oh my gosh.
We didn't call each other this morning.
No.
I promise.
Are you okay? I wouldn't notice. I'm not really functional in the morning, despite maybe how I sound on the podcast. But, whew. Okay.
Well, and this is a big treat for me because obviously you and I met through Spencer, and you know it's fun to have the crew together here today.
Right.
Yeah.
The OG.
The OG.
We got a little
Right.
history together.
We do.
Going back
We do.
ways. Yeah.
For
do.
sure.
So-
For sure. And we're definitely talking about something that y'all are way more qualified to talk about than I am because candidly, I don't know a whole lot about probate. I was just talking to you about asking you some questions about it before we went on the air. So I'm glad we're talking about this because it is something that people need to know a little bit about because when it happens, things can kind of go crazy if you don't have an understanding of what's actually going on.
Wow, that's like the understatement of the year.
I agree. Yeah,
Yeah,
for
okay.
sure.
It goes crazy real fast.
Yeah, absolutely. Absolutely.
Awesome. Well, first of all, I think a lot of people don't know what the word probate means.
That's a good point. Yeah.
So, Spencer, what does the word probate mean?
Probate, basically, from a legal perspective, is just the judicial process that you go through to essentially pass property to whomever your heirs or your beneficiaries of your estate are. That's, in a nutshell, what it does.
But I have to be dead to do that, right?
You do have to be dead to do
So this
that.
only comes
yes.
up when people die, which, as you say all the time, it's a morbid subject.
It is.
But it's something
Yes.
we have to discuss because it's really important.
Yeah, it really is. Well, and there's a lot of different thoughts about probate, and when people use it in just a general context, they usually throw it around for this kind of nebulous world that encompasses everything, and at the same time, no one really seems to know what exactly it encompasses.
Right.
So I always explain to people that probate kind of falls in this perfect trifecta of estate planning, asset protection, and probate. And they all revolve around at what point somebody passes away. And when somebody passes away, that's when we kick into the world of probate and everything that is involved with passing someone's interest in property, whatever that interest may be. It may be as simple as owning a house. It may be far more complex as owning a interest in an oil and gas lease that has been subleased at least 15 times to 38 different companies.
Yeah.
So
True story,
in
yeah.
each of those situations, you have to go through the process of actually either probating a will or going to the probate courts, which and when you have a will, you would do the same thing there. And having that interest passed to either who you've chosen in the will or who is your heir under Texas law.
Yeah.
So,
And the whole process, we're going to probably get into this in a little bit, but the whole process is complicated because you can't turn around and ask the person who has passed away what they wanted to do, like you would with a normal witness in court. You know, you don't have that person sitting there to ask the questions. What did you mean when you said this in this contract?
Yeah.
Well, they've passed away, so kind of flips a lot of things on their head.
it's a complication.
It is. And in fact, it's actually very interesting that you use that example. You can't go beyond the grave. You can't have a seance in court and be like, oh, Ouija board, tell me what they would say, right? And so there are actually restrictions, and we can get into that later, called Dead Man's Rule, about what evidence about what the dead person said can be used in court. I had a case where the Dead Man's Rule was critically important, and it came up a lot. And so that was one of my more interesting cases that went to trial. But, I'm sure everyone also is a little confused as to why someone would go into, frankly, a morbid line of work. I mean, you're not like a mortician, but I deal with airplane crashes, so I'm sure that's morbid too. But Austin over here deals with like commercial lit, family law, crime, people are alive generally.
Right.
So Spencer, tell us why you decided to get into probate work, quickly where you went to school and where you presently work.
Okay, so I went to Baylor Law School back a few years ago, and that's actually where you and I had met.
Yes.
Yes. And I even before going into law school, I'd always been interested in kind of the estate planning and probate arenas. And the reason being was pretty simple. I found those areas to be steady and consistent, and they allowed for a relationship with the client that I knew was going to be beneficial to the client. It was personal. You weren't interacting with necessarily an insurance company or a business, but somebody who you had a meaningful impact upon their life and the resources and the legal advice that you provided. But aside from that, I never had an interest in doing big law, as they call it, and working for a law firm that was more or less a meat grinder. And probate does not lend itself to that kind of lifestyle. It is steadier. It does allow some level of balance, not all the time. I mean, any area of law is going to have a crazy day. So I was attracted to both, the, for lack of a better term, family-centricness of probate, but also the fact that it could afford me a life that was not just insane in terms of hours. Yeah. So, yeah.
And one question I want to make sure our listeners kind of understand. You use the term estate planning, and we tend to know what that means, but kind of breaking it down for our listeners, what is estate planning in your mind?
So I base it off of, use the focal point of somebody's death. Before they die, they have to plan for how their property passes. And that's what we refer to colloquially as estate planning. Okay. Obviously, it can be far more complex than just that statement alone, but usually involves the drafting and execution of a will or a trust with the purpose of, or the ultimate purpose of, when the person passes away, that property that they owned at that time is going to pass to the certain people named in that will and that trust. And that process of passing that property along to those folks is a judicial process known as probate. Yeah. So that's kind of how they all come together, if you will.
Yeah,
so,
well, and like you said, a lot of times we as lawyers even just kind of throw it all together and use one word, but that's a great explanation of how that stuff fits together.
Yes, and outside the context of the law, people kind of think of probate, and again, it's one of those terms that we've heard it with a number of other terms in the law that everybody's like, oh, well, you got to go to probate, and you got to probate, but nobody really knows what they mean by probate, and it really is a judicial process. So.
Well, I like that, and you use the word judicial process. And so for some of our listeners who may be fairly savvy in this area, they'll say, but Spencer, don't you know that you don't always have to have this lengthy judicial process when someone kicks the bucket and I'm trying to distribute their assets? I have this thing called an independent administration. So I want you to kind of back up and give us like a 30,000-foot view of typically what happens in Texas in a simple case where, say, Brandon has died, and Brandon was married with no children because he died tragically at the age of 30 in a car accident and had just been married for 2 years to the love of his life, and they have no children, and she doesn't either, and he dies, and they own a house, but no other assets.
Okay.
What happens? And take it from there.
Sure. Well, so much of it depends upon whether or not there was a will. Let's say they don't have a will, and then we have to go through. So again, the house has to go to somebody. Any of the property, and I'm assuming Brandon probably had bank accounts. Brandon probably had a car. Brandon probably had other assets that, at least if he had not purchased before they were married, at some point during the marriage, he also purchased those as well. So they've got to go somewhere.
And why is that important if he purchased them before or during marriage?
Right, and that gets into, and I'll kind of tie this in as we go. Austin, I know you've got something of a family law practice as well. Property passes to individuals often based on how it's characterized and what they call the marital characterization of property. It's important, and this requires yet another 30,000-foot view. In Texas, we're what we call a community property state. And I know I'm not telling y'all anything you don't already know.
But our listeners might not know this.
But our listeners, it's really important to know. In the United States, you've got about 9 states that are community property states and about the other 41 that are common law states. And in the community property states, all the property that you own during a marriage is presumptively community property. And it means that the spouses own it 50-50. So if you bought a car together or during the marriage, that car is presumed to have been owned 50-50 between the two of you. Now, the only way it's not community property is if you inherited something during the marriage, such as your father passes away and his estate comes to you, and the $1 million life insurance policy that passed to you, that is now your separate property. And the difference from a daily perspective is not big, but in two events during your lifetime, or rather at the end of your lifetime, is when community property becomes a big deal. And that's A, when you get divorced, B, when you die. And
if you get divorced, let's be hopeful here.
Yes.
Which you're not, that's
I used
not
the
happening.
wrong term. Yeah.
So it's basically those two things come up when either A, you call me, or B, you call you.
Right.
Yeah, there you go.
Between the two of us, we
Call
have
one
it
of them,
covered.
y'all. I don't do that stuff anymore.
And here's how that's applicable to Brandon's situation.
Yes.
You know, when Brandon has passed away, and again, it depends upon whether he has a will or not, what's going to be in Brandon's estate? You know, we throw that term around a lot too, but the estate, from a legal perspective, is the property that Brandon has an interest in when he dies. And everybody has an interest in, A, their separate property, right? You own 100% of your separate property, and B, 50% of the community property, because that's what a spouse owns. It's a 50-50. So 100% of the separate and 50% of the community property are in Brandon's estate, and they've got to be given to somebody. You know, now if there's a will, hopefully Brandon put together a will, and usually in that situation, everything's going to go to the spouse. So surviving spouse, and I don't know that we gave her or him a name.
Chrissy.
Chrissy. All right. I'm working with the names.
Brandon and Chrissy.
Brandy
We
and Chrissy.
love them.
We didn't go with Joe and Diane, or Jack and Diane.
No, we
anything.
didn't, because I am very upset by watching The Crown and seeing how terrible Princess Diana was treated by the Prince of Wales.
How
Okay,
dare she.
this is a tragedy. It's a national tragedy.
God save the Queen. So
We're outside of my wheelhouse now, definitely. So
I think we're outside of most Americans' wheelhouse at this point.
Not if they're ladies.
We leave that to the Brits.
Okay.
But no, with Brandon, if he dies with a will, hopefully it all goes to Chrissy.
but that will's going to say where it goes. It may not go to her, but it's going to dictate, right?
It's going to dictate exactly where it
So
goes. Maybe it doesn't go to Chrissy, and we got a whole different question, or a
Right.
whole different set of circumstances.
Maybe Brandon
So-
was a two-time cheater and a nasty person, and only tricked Chrissy into thinking she was the love of his life, but he was secretly seeing Cristal, the stripper at the local strip club by the gas station, and was like, I'm in love with Cristal, and I want everything to go to her. And he says that in his will.
It would not be the first time, sadly.
Yeah, no, we definitely
So-
need to hear about that. And I know
Yeah.
we'll definitely get into that probably here in a little bit about
Yeah.
how that works and how you fight it. But
Yeah.
but on the will, if it goes through, if he's got a will, it's going to dictate it, and then if he
Right.
doesn't, what happens there?
So if he doesn't have a will, then the laws of the state of Texas, what we call intestacy. If you die without a will, you die intestate. We love creating words in the law.
Yes.
And I'm sure there's a Latin root somewhere for it.
There is.
It's a lot easier to say without a will, but in Texas we refer to it as intestacy.
Definitely.
And at that point, the estates code for Texas develops the family tree and determines who that property is going to go to. And this is where the community property versus the separate property really comes into play. For Brandon, when he passed away without a will, any community property that he owns, that half of his community property is going to go to the surviving spouse, which makes sense. And if everything was community property, fantastic. She's going to get it all. The problem is, if Brandon is 30 or slightly over 30, and they've only been married 2 years, it's likely that his own property from well before the marriage, which would make it his separate property. And under Texas law, when you just have a surviving spouse and no kids, you've actually got your separate property, a portion of it, is going to start going to your parents. So, which, from a logical standpoint, the law was developed because they do want to make sure that other parts of the family are receiving an inheritance and are not left out there, with nothing.
Yeah.
But it creates a situation where you're going to have joint ownership between spouse and parents. Which makes real property hard to sell.
Yeah.
You're getting into all sorts of different dynamics. It gets ugly really fast. And so you're creating for yourself, potentially, some interesting situations for your surviving spouse if you pass away without a will and you have owned a significant amount of separate property, prior to the marriage.
Yeah.
And add kids to the mix, and it gets into a whole different discussion.
Right.
Add a second marriage to the mix, and we've got ourselves the perfect ingredients for just an insane situation.
Perfect. Let me give you another hypothetical.
Okay.
I know. Don't we love hypotheticals?
They put you on the
love
spot.
Yeah, I know.
I do.
I know. She does this
was-
frequently.
Every day at dinner. 2 bites into the dinner. Honey, how was it?
Yeah, choose wisely. That's all I can say. That's what I've learned
Literally.
from marriage.
Now I wait 4
I hope
bites.
that's what Brandon's learned from marriage.
Yes, Chrissy's also an aspiring chef. Anyway, so we're going to make this real interesting. Chrissy and Brandon are married 4 years. They have a beautiful baby girl named Annie, and they have a beautiful baby boy named Johnny.
I'm trying to keep up with the names. But
I know. Do you want me to draw you a chart?
I may need one here. And I draw charts frequently when it comes into certain
Literally.
situations.
Yeah.
Okay. Brandon then is being a terrible person because he's hoeing around with Crystal, and then he gets divorced from Chrissy. Okay.
Okay.
But then
I'm following.
he marries Crystal. And then a week after the marriage to Crystal, he gets hit by a bus because he's a terrible human being and dies. And so now what happens if he doesn't have a will?
Well, if he doesn't have a will, Crystal is now the surviving spouse. And in that situation, if they've only been married a week, it's very likely that, yes, all the property that he and Crystal owned, is presumed to be community property, and they own 50-50, which would encompass pretty much everything that Brandon, had probably from his previous marriage. The difference being that you can prove what is separate property and what is community property. And if he got a proper divorce from already
Chrissy.
yeah. If he's already gotten the divorce, it's probably easy to show what is his separate property. At that point, though, Crystal is going to be sharing a lot of this separate property. She's going to get, if it's, for example, the house, if he got the house in the divorce decree and it's all his separate property, Crystal gets, and this is where Texas law is interesting, bear with me here, she, as surviving spouse, would get a 1/3 life estate in the house. And the kids, the two, Johnny and
Annie,
Johnny and Annie, will get the remainder interest in that house. And oh, by the way, as surviving spouse, she also has what's called a probate homestead in that house. So she gets to live there without having any kind of creditor or judgment creditor coming to try to take the house from her. The kids cannot force her to leave. The only way she leaves is if she passes away or abandons it. So you're creating this absolute mess. And a will would better determine where things would go. But I've seen this situation before. We're having to litigate a case that involves not Crystal and not that juicy.
I was saying Crystal is real?
Not
What?
that juicy of circumstances. But it's a classic scenario of, spouse A is married, has kids, and then divorces, or spouse B passes away, whatever it might be. And they go and marry a second spouse years later. They've accumulated a significant amount of wealth, but they go and get married without a prenup. And right after they get married, spouse A makes a new will and says everything goes to this new spouse. It doesn't make any provision for the kids. So without that kind of planning, you're now opening up a whole nother question about the kids going, well, where's our part of the share? Not even just from a money perspective, but also from the heirlooms, the pieces of sentimental value. There's a lot to be said for that.
Grandma's ring.
Yes.
Great grandpa Turner's barber jacket. I don't know. I'm just making things up here.
You would be amazed. We recently have settled a case in which we're talking about everything from pictures of their great grandfather that fought in World War II to a variety of other things. So that kind of just brings full circle the point that probate involves so much more than just dollar signs and real property and the shuffling of assets. It really does come down to there's a lot of sentimentality. You have to remember somebody's died, and it's someone's loved one, and that fuels the emotion behind a lot of decisions. And as counselors, you really have to hold their hand, walk them through it, and at the same time, be the person that sits there and goes, we need to pump the brakes. You need to be careful how you make your next decision on what you do. And it does have financial consequences for everyone involved. So
And that life estate, I just wanted to touch on that real quick because the life estate, you explained it. I mean, it basically means a life estate means you get to live in the property.
Yes.
You know, they can't be forced out.
For a lifetime.
Right. And it's because I actually, identical case that we're just wrapping up right now where previous spouse comes in and there's a fight over the piece of property because it's a $11 million piece of property. So
it's nice piece of property.
And that's the other thing, we didn't say this earlier. The reason these fights happen, they don't just happen because it's complicated. They happen because there's money involved.
Yes.
You know? And so if there's only 20 grand in the estate, you're not going to see a lot of people coming out of the woodwork to have these fights.
Yeah.
If you've got a $11 million piece of property, well, okay, now everybody wants to say that they get this and all that kind of stuff. But it does create complications because like with this piece of property, it's undeveloped. One party wants to sell it, one doesn't want to sell it. And then it's like, well, okay, what do we do here? Because new spouse has that life estate. She doesn't have to leave, you know, and then you got to get into all these other procedural complications that we don't need to get into.
Absolutely right.
But that's probably, and I think we'll probably say this a couple times throughout this podcast today, but I'm sure because of how complicated this stuff all sounds, this is why we tell everybody, including our listeners, get a will.
Yeah. Oh,
get a will.
To
save yourself.
Our prior guest, Jessica, whom, you know what, you did not say where you worked.
I did not. I'm sorry.
Probably. What do you have in common with Jess, the adoption queen?
No. So Jessica's actually my colleague over at Farrow Gillespie Heath Witter. So we're a Dallas-based law firm. We're actually a women-owned law firm, the largest or one of the largest in Dallas. Jessica is one of our esteemed senior associates, and she's obviously, you know, you got to see her on the episode the other week. She's a phenomenal individual, both as a professional and just as a human being. In general. So, but I work there. Jessica also does some of the probate work. And there's about 4 of us that do probate litigation, and then several more of us that do estate planning and the actual drafting of the wills and the trusts on the front side during someone's life. So it's a great place to be.
I love it. And since we're speaking of workplaces, I think maybe we've convinced some of our listeners, you certainly have me convinced, that I should get a will. I want a will, especially in the era of COVID. I want a will. So if I am Susan and I say...
More names, okay.
More names. Get ready, guys. I say, I want a will. I just got married a year ago, pre-COVID. Thank goodness. Had the ceremony of her dreams. And her husband is named Johnny.
Okay.
Susan and Johnny say...
Susan and Johnny.
We want a will, and Susan is 5 months pregnant. She's like, I realize I'm about to have a baby, and that makes me think of mortality, so I want a will.
Okay.
If I say it enough times, people will think that they also want wills, which they do.
Right.
Okay.
I understand.
Do we see where I'm coming from now? Okay, repetition. She's confused. Where does Susan even start?
Sure.
To look for an attorney, because it has to, right? She should go to an attorney to draft her will. What does she look for? What can she ask her friend Austin, who does not specialize in transactional probate matters, to draft a will for her? Or should she should go to someone else? Just walk her through step 1. She knows nothing about probate beyond this episode.
Well, the way folks usually come to me is by referral, and it comes from either their financial advisor or an attorney friend, or even sometimes another client of mine that happens to know them and refers them along. And you know how this works. So much of it is, who do you trust? You know, there has to be that trust that is built in with your business referral partners, your clients. They have to appreciate the services that you have offered them, and they will therefore forward along your name. And that's typically how it comes. In that case, Susan really needs to find somebody that she gels with. And it needs to be, more technically, an attorney that does estate planning and drafts wills and trusts on a regular basis. You know, depending upon Susan's circumstances and the assets, you know, there are times where you can maybe get away with somebody who, that's not their area of practice, but they throw together a will anyhow. And that sometimes might work. But estate planning and probate are always more complicated than what people realize. Each asset is kind of its own little journey about how it needs to be given to the individual, you know, in the will, and how, what the tax ramifications are, IRAs, 401ks, those are all great examples. How to coordinate with your your probate versus your non-probate assets. And in those situations, an estate planning attorney is the best person to go to and discuss that with. And then obviously to meet all the requirements and the execution requirements of putting the will together and actually signing it.
Yeah,
so,
well, because part of the thing about it is that your papers don't get graded when you draft a will until the person's already passed away. So that could be 30, 40, 50, 60 years later.
Yes.
And so then you may realize at that point, well, the person we used was not a estate planning lawyer. And now we made it, my deceased grandfather made a mistake, but can't really do anything about it now because we're stuck with it.
Yeah,
the minutia. I mean, it's a detail-oriented profession or area of law, and the minutia is important. I mean, for example, if you put in the bottom right-hand corner of your will a place for what we call the testator, the person that's making the will and is going to sign it, if you put a box for them to initial every page, they better initial every single page. If they do not, there are cases in Texas that point to that this will is either not valid, not because they haven't signed it, but because it appears that somebody shuffled papers and added portions to that will that were not part of the original will. And at that point, we don't really know what part of the will is valid or not, and the court won't take it.
And I just want to throw out this example to really impress upon our listeners how crazy the world of probate is, right?
Yeah.
Spencer, you've told me this story, right, where there are cases where people, they're dying, they're alone, tragic life, and they literally write, like on the wall in their own blood, their will, right?
Yeah, that's an actual case.
That is an actual case. And what's the important thing about that case?
Well, there's a variety of different important things.
Let me set this up for you a little bit better.
Toss me another softball.
Okay. So let's say Johnny goes hunting.
Okay.
Everyone loves a Dick Cheney moment. I'm showing my age.
Wow.
He goes hunting. He gets shot with birdshot. Is that the word for it? Birdshot?
Close enough, yeah.
Close enough.
We're in the right direction.
And so he's in his cabin while his friend who shot him by accident is running to go get help. And he's like, oh no, I'm dying. Let me write in my blood on this piece of paper my will. So he writes his will, which is everything goes to my wife. But, interestingly enough, there's a letterhead on this lovely stationery. His friend's letterhead. It's pre-printed on the stationery. What's different about that case versus the case where someone wrote their will on the wall in their own blood?
I think that's a question of testamentary intent. And when I say that, it is you have to intend to make something your last will and testament. So in Texas, we have what's called holographic wills. If it's all in your handwriting and you sign it, and you display testamentary intent, that is a will. It is a valid written will, which is the reason why, writing something in your own blood, somehow a court found that to be, I think it was on a car window in a car crash, if I recall the case correctly.
Gruesome.
That has been held to be a will. I mean, it is all in the testator's handwriting. In the situation of writing, on the letterhead, as long as it's intended. Now, I can't think of an exact case where that's come up, but as long as it's intended to be a will and it demonstrates it with the writing, I give everything to my wife, that's dangerous, actually, because that doesn't suggest that it's at death. That actually suggests potentially that it was intended as a lifetime gift. So if I was on the other side, and I've got kids and this is a second spouse, was it Johnny that got shot? The names seem to change a little bit.
Yeah, we'll go with that.
We'll go with Johnny.
Yeah.
Johnny got shot.
Johnny got shot. I would actually, if I was his kid's attorney, I would say that's not a will. And so he didn't intend to do this during his lifetime, or excuse me, at death. He intended to make a gift right then and there of everything he owned. So that just highlights how important it is to do the will correctly. Don't write it yourself. Get somebody in that actually understands all the nuances and the details that are important. I do think it's worth, and if I may actually pivot the conversation myself.
Wow.
I know. Well, I've watched enough episodes. I've seen how y'all do this.
I love to pivot.
Yeah, pivot. I think that's the word of 2020.
Take it away.
Isn't it? Pivot.
Sure.
So there's an importance to understanding mechanically what probate is and why a will is important in that context, not just in the family context of who's getting what and how is it put together, but I use the word mechanically with my clients because that seems to connote a little bit more. Here's the practical steps of how probate works.
Sure.
I'm going to go back to Brandon. Let's say Brandon had a will.
Okay.
And this is how that whole process works out. That will is useless until Brandon passes away. It means nothing. It's not effective. It has no purpose other than words on paper.
Right.
And it's been properly signed and hopefully, attested and with the notary on it.
So kids, be nice to your parents.
Right. So at the point that Brandon passes away, let's say surviving spouse, somebody who is named as executor under this will is going to take that will, and if Brandon lived in Dallas County, we're going to say he's going to take it down to the Dallas County Probate Court. And
What's an executor?
It's an executor? Okay. So whenever you pass away and you have an estate that, is all of your property or your interest in property, the executor is the individual that you've named under your will, could also be a corporation, like a bank, that is going to manage your estate. And essentially what an executor is supposed to do is they marshal the assets. So they're going to bring everything together. They may be consolidating all your accounts into one bank account for the estate.
Right.
They're going to pay any debts that are properly made against the estate. If you've got a credit card debt and you pass away and they properly present it to the executor usually is going to pay that debt. And then at the end of all that, the executor gives all the property to whomever is named as beneficiaries under the will. It works similarly if you don't have a will in which it's no longer an executor, it's an administrator. Right. Because you haven't actually named that person under a will. It's the court had to find somebody to serve as the administrator.
So the executor grabs the will and then goes down to Dallas County.
Or whomever has the will. You got to go find the will. That in and of itself can be a journey.
Right.
Interesting.
But which is interesting to note. Whoever has the will or has the original will is quote unquote a custodian. And they are under a duty to provide that will, even if they just give it to the clerk of the probate courts. And it's also important to note that probate is its own special court system. Right. It's what we call...
It's still civil.
Yeah, it's still civil. It's referred to as probate jurisdiction. Right. And basically, the larger counties have what they call statutory probate courts. The Texas legislature created this special court system to deal with people's estates. And
it makes sense because we're spending an entire episode talking about how complicated this system is. And so it's nuanced. And so it's nice. You want to have judges that understand the ins and outs of all these types of complications.
Absolutely. Yes. It's its own unique area. It operates by its own... it follows very similar procedures to usual civil law, but there's a lot of different little features to it that don't play the same. They don't play the same kind of ball game that a typical civil litigator would play in a normal district court. So that's all very important to keep in mind.
Well, and you mentioned that the mechanics of how the process works are important, and so and I think I kind of know where you're going with this, but kind of explain to our listeners why that really factors into when I'm putting a will together on the front end while I'm still alive.
Sure. So. When you take the will to the probate, so the executor or whomever has the will is going to apply to the Dallas County Probate Court, and they're going to ask for that court to essentially give its stamp of approval on the will. This is a valid will. It was correctly done. You're going to have a hearing. You're going to have to prove up the will, show that it was correctly executed, and at that point, the county, or rather the Dallas County Probate Court, is going to also say this is a valid will. Brandon's will was correctly done, meets all the requirements. The person named under the will, usually surviving spouse, is going to be the executor of Brandon's estate. They're going to perform all the functions that we just mentioned. We give them authority to do so. And by the authority of the state of Texas, the executor can go to the banks, they can go to wherever they need to go to marshal those assets and eventually give them all to the beneficiary of the estate. That's a much smoother process with a will, and it costs less money, it's less time, it's less effort.
Because you got a game plan.
Right, you have a game plan. You have a roadmap of how this is supposed to all work out. When you don't have a will, you have to add multiple more procedures in that probate proceeding to get to who gets the property, who's going to serve as the administrator, which means time, expense, money, more attorney's time. As everybody knows, we do charge by the hour. So
we do.
Yes. So
and part of the problem with that is, and we won't get into all this because it's just far too complex. But the different decision trees that come out from if you don't have a will, then here's how the assets are delved out. I mean, it's insanely complex, and every little wrinkle can make it even more complex, and you get layer upon layer. And that's one of the main reasons you should have a will, because then the expense of that, because by the way, the expense of sorting through that mess, what's coming out of the assets you have, and that means it's taking money out of the pockets of your people who are supposed to receive your assets, because those assets are having to pay the lawyers to fight through all this.
That's exactly right. Yeah, at the end of the day, and I hear this from folks that are contemplating estate plans, or actually folks that just keep putting off getting estate plans. They're like, well, why do I care? You know, that's money I'm not going to be using. I'm going to be dead. Right. They're like, well, you know, at that point when they're making that kind of comment, you know, you're fighting an uphill battle to explain the value of an estate plan. But I do explain, you do have a responsibility to, with what you have, to enable a legacy for those that you leave behind, and to leave it up to chance, to leave it up to the laws of intestacy. I would not call irresponsible, but I would call it an unfortunate. You lose control, you lose the ability to affect change in people's lives and give them the opportunity to, you know, pursue their dreams and their career and their hopes and desires.
And this is one of the most critical points, and I want to make sure that everyone is aware of this. If you die without a will, who's going to take care of your pets? What's going to happen?
That's actually a good point.
What's going to happen to Fido and to Fluffy?
Yeah.
Where are they going to go? Are they going to go to the shelter
that.
and be euthanized because of your carelessness?
I should have known you were going to bring that
What the heck?
Andrea.
No, that's a great point.
Where will our cat go? You know,
Oh, that's already planned out.
I know it is.
Yeah.
Yes, I'm aware.
But that is interesting though when you put that out, because like pets in a divorce scenario, far less things you can do with that in a divorce case. But in probate, it's a little bit different because just the scenario is different.
You can. There's actually something called a pet trust.
I want one. Draft me one, please.
I have put them together in people's wills before, and you'd be amazed at the amount of money that people fund those pet trusts with, and understandably, you know, the pets are of tremendous value to them in their lives, and they want to take care of them after they're gone. So,
all right.
Yeah.
Spencer, such wisdom today, especially the pet trust. Seriously, y'all remember that. And I do want one. Christmas present? Anyway.
I'll think about it.
Thanks, honey. Okay, so top 3 takeaways to wrap this up. Top 3 concrete takeaways that Susan can take away and remember from this episode.
Okay. Well, first is get a will.
Get a will, get a will, get a will.
If we haven't made that clear enough already, you know, and that's not just Susan, that's Billy, Bob, you know, and every other name that you came up with today. You know, everybody needs a will. You know, I think that would be the first takeaway. Second takeaway would be probate is never simple. There is no such thing as a simple probate. Right. And I say that for the folks that are coming in for their loved ones and trying to go through the probate process. I want to manage those expectations. I've had a client recently that it has been difficult for her to appreciate, you know, the circumstances, the nuances, the detail that goes into having to probate and figure all out the assets. Yeah. So understand that. And then third, you know, I go to choosing a lawyer for the probate system. Yeah. Find somebody that works with you, that you can trust, that communicates well. That sounds like finding a spouse, but it's
not so different.
Right. Look for the same qualities.
Yeah.
You know, they don't necessarily have to be, you know, cute and gorgeous and all, but you know, you do have to. So, but it is important to work with somebody that you know not only has your best interests at heart, truly, and not just in word, but actually in deed, but also understands the process, is going to communicate it to you, and can explain the depth in detail required. If they're just kind of glossing over the probate system and how it's all going to be easy and straightforward, it doesn't work that way.
Well, because it's a highly personal thing you're doing.
It is.
I mean, planning out your potential demise or eventual demise, is it's emotional. It's highly personal, and so I agree with everything you're saying. You've got to feel like you're with somebody you really trust to have those conversations with. If you don't feel comfortable having those conversations, well, you're not going to be getting the best service out of your probate lawyer or your estate planning lawyer, because they're not going to get to learn everything they need to learn so they can do the best job possible for you. So I think that's a great point.
Yeah, and I'll add a fourth point just as a
please.
Wow, rebel.
I know. Go back to that focal point: death. After death, probate. Before death, estate planning. You know, and they're both interrelated, obviously. But estate planning is everything you do prospectively. Probate is everything you're having to do reactively. You know, and that's kind of the important distinction for people. If you take away anything, know those two, and that kind of helps you make your decisions moving forward.
And on that lovely and morbid note, Spencer, Sunshine, thank you so much for blessing us with your presence today and dropping wisdom on a topic that is extremely relevant in these COVID era times.
Absolutely. So, thank you for having me on. It was a pleasure.
Come back on anytime to talk about preferably trust and pet trust, because
it won't take 30 more episodes, will it?
We'll see. I'll ask you back
see.
too.
Okay, good.
Yeah, listeners, comment on my Instagram if you want Spencer to come back. We'll leave it up to the public. Let the public decide. All right. Y'all, thank you so much for tuning in. And seriously, let me know if you want to see Spencer back on here. And we'll catch you next time.
Thank you guys again for listening to us here on #Lawyered. Go find us on whatever platform it is that you listen to your podcasts. Go like the podcast, go follow and subscribe to us. Leave us a review, leave us a rating. That helps us to really get the word out and really continue to tell you guys about all the different things that are going on in law and business here in Dallas. Make sure you check out our videos on our YouTube channel. It's #Lawyered. And then also follow us on our Instagram account. It's at #Lawyered. DM us, send us some issues, some topics you'd like to discuss, or some things that maybe you just don't understand about the law, because we want to make sure and cover and give you what it is you want to listen to.
Welcome back to Closing Arguments, y'all. Miley Cyrus has come out in an interview saying that there was just too much conflict in her marriage to Liam Hemsworth. Can she come out and say that? Yes, she can, because there is not a gag order in place. Free speech, y'all. Stay tuned for next time.